it's such an interesting area to talk about when you talk about restricted stock units, because restricted stock is not always actually vested. And sometimes you might be starting a divorce and you might have restricted stock units that are not vested. The way to deal with this sometimes is to figure out, is it an incentive? In other words, are you incentively getting these restricted stock units to keep you in place and forward-looking, essentially, or are these restricted stock units being given as a bonus for work already performed during the marriage? Now, we have in New York something called the date of commencement of an action. So you file your summons, and at that point, the action commences as long as you serve within 120 days from the filing. It's really important to understand, as of the date of commencement, what were the vested units of the restricted stock and what are the unvested units? And then whether the unvested units are a bonus for the work already performed in the past during the marriage before the date of commencement, or are they future looking, so that essentially like golden handcuffs, that you're keeping the person there as an incentive. If they're an incentive, then we look at what's called the De Jesus formula, which is a coverture fractional formula, so that you are getting basically credit for working. The person who's working is getting more credit for actually working through the years. And the other person, who is not the non-working spouse at that point, who's not, or the person who didn't receive the restricted stock units, is not cut off entirely, but they are getting considerably less as the years go on, and you're working more years to get that restricted stock unit to vest. And so you need to actually look at the award documents and the grant documents in order to actually determine what is the formula here and whether it is past performance or future performance.